Right. Good morning, ladies and gentlemen. It is a great pleasure and a privilege to have been asked to give this plenary presentation today. Why it is so is because of a number of reasons. I will mention one. My specialized field of expertise is really actually comparative law, which is, it has a very close connection to legal translation. In comparative study of law, we examine different legal systems, legal texts in different languages. This means, of course, that when comparatives does research, they must use sources in different languages. And commonplace, this seems to imply that comparatives must always do translations from source languages to target language. And when this kind of a sort of a research-related inevitable translation takes place, corollary issues concerning legal language and legal translation normally arise. So for comparatives, legal translation is tremendously important, since the flow of information between legal systems or legal cultures, it takes place through translation. So for comparatives, legal translation really lies at the heart of the matter. And that's why I can say really that it's a great pleasure to be able to give this plenary. Now, the theme of this conference is translating and interpreting as a means of guaranteeing equality under law. Although the question concerning equality under law is by no means irrelevant or untimely, I have chosen to discuss legal translation and legal interpretation. This decision is based on an assumption according to which looking into the relation between translating and interpreting, it brings forth fundamentally important issues concerning translating legal language. It seems to be the case that it's generally accepted that legal translation and legal interpretation are closely related. Different things, yes, but closely related. So there are a number of professions that are interested in both of these. Of course, lawyers working with international or non-national legal issues and translators translating legal documents are prime examples of professions dealing with legal languages. And of course, there are also various academic disciplines that are interested in legal translation and legal interpretation. In disciplinary terms, we can separate roughly translation studies and legal studies, which both deal with legal translation and interpretation. Normally, we seem to think that lawyers are mostly interested in interpretation, whereas translators are interested in translating. This common wisdom is, however, distorted in a sense that translation and interpretation are typically intertwined with each other. They are difficult to tell apart. In other words, translators must step into the realm of law, and lawyers, in turn, must step into the realm of language. Now, even while these views are intertwined, there are also relevant differences. And in this presentation, one key facet of these differences is discussed. The binary opposition of these at least two seemingly opposing views is examined especially in the light of contract law. So I use contract law as an example, but I'm not going to do anything that has to do with concrete legal questions, nor am I going to give any examples concerning how to actually translate contracts. But it is a sort of a theoretical area of discussion that I sort of just use for the benefit of this presentation. So the idea is really to apply contract law theory to the analysis of differing epistemic points of view. However, perhaps I should say already at this stage that even while these views are not similar, it does not mean that these views could not coexist and interact in a fruitful manner. In fact, the idea of interaction is really an elemental part of the argument of this speech. But before going further, one key remark needs to be made. This presentation, which is, as to its nature, kind of a brief overview, it deals with legal translation so that it discusses broadly both language and law. This means, likely, that the present argument situates between different disciplines, and thus it lacks scholarly nuance if looked from the strict viewpoint of a certain academic discipline. But I do believe that discussing about legal translation automatically ejects one to a kind of a shadowland, which is outside the borders of established disciplines. So, in a certain sense, I suppose this talk invites you to walk with me in the shadowland of legal language. Now, for the purpose of this presentation, I think it's useful first to define what it is that I actually mean by legal translation and interpretation. This is needed because there are, as we know, different ways to understand both translation and interpretation. And in this presentation, I confine myself to legal interpretation. I'm not speaking of language interpretation. So my focus is actually on legal translation. So to begin with, legal translation has basically a rather straightforward goal. It is to construct a text that has equivalent meaning as understood in the target legal system and in the source legal system. Now, it's crucial to underline that equivalence does not mean or require that translators' task would be sort of to fade out differences between the between different legal cultures, between target language and the source language culture. Instead, I suppose the underlying idea is to not to get rid of linguistic or legal cultural differences, but rather to accommodate them. And this kind of translation has, as we certainly know, its own difficulties, because legal texts are structured and patched in a manner that suits their particular legal culture. And obviously this particularity is also reflected in the legal languages. Correspondingly, translated target text is utilized normally by someone who is familiar with a different legal system, with different legal cultural background. So it seems that the whole point of legal translation is to sort of linguistically transform the original text so that it becomes operative in the target language. And this brings us to interpretation. There are views claiming that translation is actually interpretation. Notwithstanding, I believe, as Umberto Eco did, that translation is only a very limited type of interpretation. Moreover, it seems to me that legal interpretation is really a very special case. In a very basic sense, we can say that legal interpretation is text-based rational activity. It seeks to give meaning to a legal text or an expression in a legal text. In general, for a lawyer, interpretation normally means that they determine the normative message which is, in a way, hidden in the text. There is at least one difference between translation and interpretation. It concerns the focus. Normally translates all of the text of document, whereas legal interpretation is much more selective. In other words, only difficult or unclear parts of legal texts require interpretation. This is because in most cases, at least hopefully, the meaning of the words, sentences, are rather unproblematic, whereas interpretation is needed only when there is uncertainty or dispute about which legal meaning one can or one should attribute to a text. If you continue this, typically it seems that we can sketch the relation between translation and interpretation on the basis of these two rough definitions I just gave. And likewise, it seems that translator translates legal document from source language to target language, and only after the lawyer comes and interprets the text, if there are these uncertainties or disputes. However, I think we all know that that the reality is more complicated than that. For instance, we know that legal translation requires familiarity with comparative law, familiarity with legal issues involving more than one country's law, familiarity with source and target languages, amongst other skills. So in short, legal translation is a demanding thing to do if it's going to be done professionally in a good manner. And as we know, there is a voluminous literature describing the horrors and obstacles involved. We can see translators trying to intimidate lawyers, and we can see lawyers trying to bully or bullying translators. Sorry to say, but we all know that this literature actually is there. You know, sort of these professors saying, this is right, this is wrong, you should do it like this, no, you should do it like that. It is there. But there is no great complexity concerning the question why there are tensions between these two points of view, language and law, or normative or translator's view. That's because they overlap each other. Legal texts, like pieces of legislation, court judgments or contracts are in the focus of both lawyers and translators. However, I think it's an important point to note that they examine legal texts from different epistemic points of view. Today, it's largely recognized that neither of these viewpoints, law, language, is really the only right one. Instead, it seems to be the case that we understand that there are differing but equally justified viewpoints on legal texts. Moreover, it is perhaps even commonly accepted that linguistic and legal approaches actually complement each other, and that both the legal and linguistic approach are not only needed but also very much useful. And I think also that the relatively new discipline, legal linguistics, seems to confirm the need for both kinds of approaches, for it seeks to construct an amalgam of the two approaches. In brief, legal linguistics fuses, or at least attempts to do so, to fuse the legal and linguistic views together. How well it does that, that's a different question, but that's what it tries to do. However, I think there is at least one crucial kind of a binary difference between the point of view of the translator and the lawyer, and when it comes to the interpretation of legal texts. And in this presentation, these approaches are labeled as the dynamic and the static views. And these, of course, comes from, also you can see in my title, Legal Translation and Legal Interpretation, a Dialogue of Static and Dynamic Views, ? So, in translator's view, legal texts or text is traditionally conceived as static, as to its nature, something that already exists in the form of text. This means, or it seems to mean, that translator is specifically interested in the text itself, as it is written down in a document. It seems to make sense. That is, translator needs to go back, in a sense, to the frozen moment when the legal document was constructed and finalized. So it's a kind of a time travel in that sense. And as such, translators' manner to grasp legal text is rigid, in a sense that they are not supposed to be responsive to the facts or circumstances or the dynamic nature of law as normative creature. Instead, at least the classical translator's view seems to be focused on a single moment in time, which is the moment when the legal document took its final textual form. So, translator's work seems to concern only written words, no more. The lawyer, on the contrary, is, or rather must be, very much interested not only in the text of the legal document, but also in the contextual surroundings of it. And in fact, for legal interpretation, sometimes, not always, but sometimes, the key elements for the interpretation come from outside the text itself. Now, dear audience, the argument I'm presenting here, it may be somewhat convoluted, for which reason I think I need to explain it in more detail. And as I mentioned in the beginning, I have chosen contract law as an example to highlight what this key argument of this presentation actually is. Before we can embark on contract law theory, I need to define what contract is. Obviously, only a very rough, tentative working definition is possible on this occasion. But before continuing, I need to make also one other remark. And this is the thing, that the way how I sketch the legal essentials of contract law are unquestionably influenced by Nordic doctrines and Nordic legal thinking. So someone more familiar with other type of contract law theory might give different kind of definition. But in any case, because my point here is more epistemic than legal, I don't see an insurmountable obstacle because of this, what you might call Nordicness. So basically, there are various ways of understanding what contract in a legal sense is. For example, common law's manner to define contract certainly differs from the manner how it is defined in Romanic Germanic law. Moreover, there are, of course, differences between Romanic Germanic systems when it comes to legally defining a contract. However, for the purpose of this presentation, I suppose we can say that contract is basically an agreement, creating obligations that are enforceable by law. Essentially, it is the agreement by both parties which creates a contract. And one of the key elements of this kind of contract is the mutual asset, which is established by an offer and acceptance. If I would be a common law lawyer, I would probably talk something about consideration, but I'm not saying anything about that. Typically, someone offers to do something in exchange for money or service, and this offer is then followed by an acceptance of that offer. Now, even while the word contract normally refers to this written document, writing is not always, of course, necessary for creating a legally binding contract. Nevertheless, when I speak of translation or interpretation, I mean only written contracts. I'm not saying anything about oral contracts, although we know that that is a possibility too. So generally speaking, translating this kind of language, contract language, has a simple goal, which is to determine the intent of the parties on the basis of the text. The mutual intention of the parties is important if, say later, court needs to settle a contractual dispute. In a paradigmatic case, the mutual intent of the parties is determined so that it's based solely on the written terms of the contract. The idea is that if the language of the contract is clear and definite, it will suffice in order to determine what the mutual intent of the parties was. But if the language is not clear, then the court, at least normally, tries to reconstruct the mutual intent by looking to the course of dealing between the parties. In other words, the court looks into the sequence of behavior when it seeks to give meaning to the language used in contract. When interpreting the language of contract, if we simplify a great deal, and this is what I'm doing, courts tend to give terms and words their sort of ordinary and common meaning, if the parties did not use the words in certain special or technical sense. And if court deviates from the ordinary and common meaning interpretation, it normally considers how the words are used commonplace within that certain profession or within that certain business. But as a rule, courts start from the written text, the written provisions of the contract itself. So they will try to avoid looking outside the contract rules, or the contract, unless there's obvious uncertainty concerning contract provision. Now, the question is then, of course, where are we with translation and interpretation then? Where does this discussion lead us, or does it lead us anywhere? If we take this kind of an understanding I've been just trying to describe of translation and interpretation of contract as our starting point, I suppose everything is rather simple. We are bound with the text, and the contract language binds both translation and interpretation. We may describe this kind of an understanding of contract as static, because it concentrates on a single moment in time, which is really the moment of contract formation. However, if we step out from this kind of understanding, this traditional understanding of what contract is, I think that the situation becomes more complicated. And that brings us to the fact that during the last few decades or so, we have seen the development of a 21st century contract law, and it has virtually overthrown much, not all, but much of the classical contract law. So the idea what contract is has changed. And one of the key developments concerns the nature of contract and the language of contract. Typically, as I described, classical contract law was by and large static, whereas this modern contract law or modern understanding of contract is at least in part dynamic. But what does this distinction between static and dynamic actually mean? I will try to explain this. For example, static rules of interpretation have been replaced by dynamic rules that take into account events before and after the contract formation. Crucially, the key elements of such contract law theory are, I think, helpful for the analysis of epistemic differences between lawyer and a translator, or legal view, or this linguistic view. The dynamic nature of contract typically concerns not all kinds of contracts, but typically it has to do with long-term business contracts. And this is because the business environment has transformed into more complex than what it used to be. And in practice, this means that doing business with help of static contracts has become more difficult. rational and perhaps indeed profitable business may sometimes require that the terms of the contract adapt to the changes of this operational environment. And these changes in the operational environment may evolve in such a manner that the whole idea of a contract as a kind of a snapshot taken at the moment the bargain was made, this view just cannot be maintained anymore. It simply crumbles, especially when we are dealing with long-term business contracts. And this new type of understanding of contract, I suppose we can call it dynamic contract. It seeks to respond to the changing landscape by trying to capture the reality, legal reality and this business reality of long-term business contracts. But the question is really, where does all this actually lead to? Where are we going? I'm afraid that there's no simple answer. It depends, of course, on what kind of an approach we assume. One approach leads to a safe haven, which is defined by document's text. Or the other approach seems to lead into the wild. If we choose this narrow point of view, I think we can say that dynamic contract is not a problem, or this is what we can argue, that it's not a problem for a translator. Translator translates merely the contract text from source language to target language. Or in other words, legal interpretation of contract language, these terms, words, phrases, expressions, are a problem for a lawyer, not a problem for a translator. You can say that. This narrow view fits, of course, well with the static contract, because traditionally contract law has concentrated on securing legally forcible obligations, which are really based on these static linguistic expressions as they are documented in written text. However, if contract is conceived as legal instrument for reaching business goals, then things may look different. We may ask, a bit dramatically perhaps, but we may ask, what happens when the tyranny of the text is overthrown, even while we still try to hold on to the idea of a legally binding contract? Now, the purpose of my presentation here is not really to dwell too much in contract law doctrine and theory, but I'm trying to discuss the epistemic difference between translator and a lawyer, or the distinction between translating and legal interpretation. And from this particular point of view, it is important to point out how the terms of contract, they change from literal rules toward signposts, informing the future directions of a particular contractual relationship between parties. And if and when we look at contracts as dynamic rather than static, then key dimension of a contract is not anymore, or not only the language we have in document, but rather we have to take into account the manner how the contract, this text, is attached to its business environment. Or in more general terms, we have to also think how the language of a legal document attaches to the out-of-the-text reality. What is the relationship between the text and the outside reality? And what does this mean for translation? Now, the lawyer's work in this kind of dynamic contract law is to filter the context of a contract as an interactive part of the written terms of the contract. Or in other words, the lawyer becomes a kind of a mediator between contract terms, outside reality, and the contract parties. Perhaps it's prudent to say at this point that what I'm saying here is not even nearly as radical as it may sound, because we still have the document and the text in it. It doesn't go anywhere. It doesn't disappear. So in short, if I draw together this above discussion now, the text of contract does not become meaningless, but it is interpreted in relation to the surrounding reality. So if we follow this line of argumentation, which I'm sketching here, the translator translates the text, whereas the lawyer interprets both the text and the contextual reality of a contract. But then again, what does all this really mean for legal translation and legal interpretation? What about the epistemic differences I've been talking about? Do they disappear or become possibly even stronger than before? Now, in the beginning of this talk, I invited you to walk with me in the Shadowland. So have I now led us into the dark? I would like to think that that's not the case. But where do we have to go from here? Where does the argument lead us? If we regard the contract as static, the function of the translator and lawyer are rather easy to pinpoint. Traditionally, contract was seen as an unchanged from the moment the bargain was made. However, when our understanding of the contract opens towards the context, towards the outside reality of the contract as document, I think that this means that legal text becomes more dynamic, but it also becomes more vague. And this, I think, changes the role of written contract language or written legal text altogether, the relation between the text and the reality. And I understand, of course, that for legal translation, this openness is a problem because translating this contract has usually taken place in isolation. The limits for translation are being given by the written document and the words in it. But, importantly, the dynamic contract is equally problematic, and this is important for the lawyer, because the lawyer has also relied on the very same idea of static contract. So the contract language's interaction with the business environment is also a great challenge for a jurist, not only for a translator. And in any case, there's a point I'd like to make at this stage, is that the antiquated idea of fidelity to the letter, I think it loses much of its relevance if translator is dealing with a living legal document. And if there are here those who resist departing from the idea of fidelity to the letter, I must say that I'm not of their number. Now, what I've been saying here, I think we could obviously draw many kinds of conclusions on the basis of what I've just been saying. But one crucial thing seems to be that both legal translation and interpretation become more complicated and demanding if legal texts turn into something which are dynamic creatures. And I'm not sure if this is a very happy news for anyone, because it wasn't easy before. And if it becomes even more complicated, well, I don't know what, but that's not a good news, I think. But unfortunately, this is the news I'm bringing. Now, none of this is really to argue. I'm saying here that translation would be, or that it will become, impossible because of the increased dynamic and the outside of the text features of legal texts. No. But the change from the static to dynamic, it has certain consequences for the practical manner in which to organize legal translation. A crucial factor is that how language-bound legal and contextual dimensions can interact in the process of translation. Instead of this one-directional process where translator translates and lawyer interprets, I think what is needed is really this more back and forth movement of different text versions, at least. Or in other words, the lawyer must obviously give feedback to translator, and translator makes modifications to the text and sends it then back to lawyer. And this kind of a process ought to go till the point of saturation is reached. Of course, I'm even painfully aware that all this requires some very mundane things like time and money, how much you can invest to that particular translation. I'm aware of that, but really my argument here is very much epistemological and theoretical. I'm not going there, but I'm just saying that I am aware of these practical difficulties, and they really are there. Now, in this process I'm trying to describe, this back and forth, the language of contract, the words and expressions, they ought to gradually gain a legally and linguistically sort of acceptable form. The translator needs the lawyer here to bring in both the legal reality and the contract reality, whereas the lawyer, of course, needs well-translated versions which to work with during the process of translating dynamic legal language. It can't go just one directional, or the results will not be very good. Now, what I'm saying here, I know that it leaves many questions open. It would be quite impossible to address all those in this presentation, perhaps altogether not possible at all. However, one of the most crucial observations concerns the nature of legal translation, what it really is, what it changes if we accept this idea of dynamic legal text, what translation actually is. if we take out-to-text reality of contract into account and distance ourselves from the text, are we dealing any more with translation, or is it something that actually goes beyond translation? And I think that the argument of this presentation, if it doesn't convince us, it at least invites us to reconsider the concept of translation when we are dealing with complicated living legal documents. And along these lines, if legal translation really becomes such that it gives more weight to context and legal culture, this outside reality, it comes closer to something that some have labeled transcreation. The underlying point would be to grasp that legal translation is not fundamentally really about, replacing some words by others, but rather it is about translating legal speech acts. Now, transcreation obviously refers to recreating a text for specific target audience. It combines translation and recreation, or translating and recreating. And this kind of a intercultural translating is clearly much more than a faithful word-to-word copy of the original text. A transcreated text is specifically aimed at a certain target audience, and it seeks to take into account the different cultural backgrounds between the source and target cultures. Moreover, in this kind of a process, it seems that a translator becomes more of a text producer than something we could call bilingual typist. And as one scholar says, legal translators do not translate words. Sounds funny, but that's what's being said. This is a crude, but I think a powerful realization. And as a comparatist, I would certainly like to add that, and I'm quoting John Bell here, that there is an act of communication which is not just a matter of translation. Something else, something far more takes place there. Tentatively, we might think that legal transcreation means to expand the traditional translation by focusing not only the text but on discerning the living legal message expressed in the source language and in the context of, in this case, contract reality. And in light of dynamic contract, my example before, I think that transcreation means that the translated text should optimally convey the reality of the contract, not only the words in the document. And importantly, this kind of translation actually means that translators they really must interact with lawyers, and of course vice versa. Or in other words, there must be an ongoing dialogue between language and law. And again, I go back to my title of this presentation, which says that legal translation and legal interpretation, dialogue as static and dynamic views, question mark. So the answer is not really that there is this dialogue, or there isn't. But what I'm saying is that there should be. So the argument here is rather normative. Now, of course, this presentation is no more than a tentative hypothesis, and obviously the observations and remarks I'm making here require deeper study before any final conclusions can be drawn. Yes, I do know that. However, I dare say that it seems even undisputed that the way how law is conceived, it has inevitable consequences for how we understand what legal translation actually is. If and when the language of law is not seen only as static, dead texts that contain hidden legal meanings for lawyers to discern, but also if we see them as living texts that are in interaction with the reality, surrounding reality, I think this means something for legal translation. It must mean. Of course, if you choose to hold the old static idea, saying that no, legal texts are as they are and there is no outside reality, or if there is, it's lawyers' business, not translators. You can do that. It may be consistent, but I'm not sure that it makes much sense, because it doesn't produce very good translation. Those translations are not very good if they are just, changing words by others. So, if I put it differently, a legal translation may many times, and I'm not saying that that would be necessarily the case always, but many times it may be something we can call transcreation than translation. And now, if you don't like the word transcreation, you rather prefer the word translation, that's perfectly okay with me, because it's just a word that says in short, legal, culturally sensitive, demanding translation. But it's a long word. So that's why I just for short call it transcreation. But if somebody doesn't like it, wants to keep the old world translation, be my guest. That's not really what I'm saying here. That's really not the key argument. Just a tiny point about the term. So I would also like to add that this example I mentioned, I used previously, concerning this dynamic long-term business contract, is by no means the only one. There are other examples available, examples that have to do with the relation between legal texts and reality. We can see similar types of development in the areas of, I can mention two examples, further examples, American constitutional law and European human rights law. For example, in American constitutional law, I don't know if you know this, but the idea of so-called original meaning of the Constitution has largely been these days rejected by many constitutional experts. Although we don't know what the situation is right now, because US Supreme Court has now only 8 justices, because Antonin Scalia, the great defender of this original meaning interpretation, has just passed away. But in any case, this originalist interpretation, it maintained the idea that the US Constitution should be interpreted based on the intent of its authors, as determined by examining the evidence of the understanding of these founding fathers concerning what is the meaning of the words in Constitution. So in short, the idea was that the courts ought to look at evidence from Constitutional Convention, ratification debates, Federalist Papers, which are essays produced by founding fathers under various aliases. You should be looking at the historical practice shortly after ratification and equivalent sources for later amendments. But in any case, the idea of original meaning, this literal interpretation, it does not do well these days, even in the United States. Because Constitution and its text is today conceived by many, perhaps by majority, as a living legal document, which evolves, it alters over time, and adapts to new states of affairs, without being formally changed. So the text remains technically unaltered, but the legal meanings are adapted to the changed circumstances. And of course, counter-arguments here could be that it's a special case, because US Constitution is so old that it can't be, we can't rely anymore on these literal interpretations. But the second example I mentioned shortly previously, European human rights law, it concerns specifically European Court of Human Rights, which uses so-called dynamic interpretation, which means that in many of its judgments, it is not completely bound by the text of the European Convention of Human Rights. In short, the way how the Human Rights Court interprets the treaty rights has abandoned textualism, and it sees interpretation sort of a evaluative task in identifying the moral values, which are somehow based on the text but not exhaustively described in the texts. This means, in practice, of course, that the case law, the precedents by court itself become more important, and they add new meanings to the text of the convention. Now, both of these examples I mentioned shortly, I think they also underline the same idea as my example with contract law. And it is this: the language is a raw material to be worked on. It is not a textual snapshot of a past moment in time, not in a meaningful legal sense. It is something which is alive. It has a dynamic character. And this means, so I'm saying something for how we should understand what legal translation is. So no matter what we think of legal translation, I think we ought to grasp that it's not only about dealing with snapshots taken at the time when text received its final form. Abandoning textualism and the tyranny of the text unavoidably brings changes, of course. And this, I think, supports the idea to which, according to which demanding legal translation is actually something we may call transcreation. To be sure, for a lawyer and a legal translator, this means that they must be willing to work more closely. They must work interactively in cooperation. And accordingly, we need really this interactive dialogue between static and dynamic views to legal language, between different professions. And this also means that we have, of course, multiple overlapping forms of intercultural communication going on in the process of translation. Source and target languages, source and target cultures, different professions, different academic disciplines, they are all interacting with each other, or at least they should do so. So consequently, both lawyers and translators become, in essence, cultural mediators when they struggle to communicate information between legal systems or between legal cultures. So to conclude, I really would like to think that this intercultural communication is, as to its nature, something which is a dialogue and not a monologue. Thank you very much for your kind attention. Thanks.